everybody. We'll reconvene the meeting of the hearings panel, and we'll move on to agenda item number 3, which is an application for resource consent RC190516, Central Otago Water Company Limited, Nelson Ridge Road, Springvale. Just a bit of procedural stuff to work through. This is a properly convened meeting of the hearings panel, called for the purpose of hearing submissions in relation to resource application to vary consent condition of consent notice 7204.122.3. I'd ask the Minute Secretary to report on proceedings to date.
All statutory requirements under Section 95 of the Resource Management Act have been complied with. A report of planning consultants has been circulated to address for service. The submissions received have been identified in the report.
Thank you. I can't multitask very well. I've got to write something down. Right, done that. The following procedure will be followed for the hearing. The panel or officers may ask questions. Council's officers or its consultant shall put any questions through the chair, and the chair shall be deemed to be the person asking the questions. The applicant or the applicant's representative shall make submissions and present evidence. The submitters or their representatives will then make submissions and present evidence. The applicant shall have the right to reply, but shall not be again permitted to again traverse the evidence nor raise new evidence. So before proceeding with the hearing, I'd ask the parties appearing identify themselves. So just working through this is a bit of a new environment, running teams. It's easy to talk over top of each other, and I'll be the worst person at doing it, but we'll see how we get on. So yeah, for the applicant, who's going to speak first there?
I'll be speaking first. It's Peter Anthony from Patterson Pitts Partners, and with me is Graham Reid, who is a director of the Otago Water Company Limited.
Thank you, Mr. Dimmock, and Mr. Reid. Welcome along. Thank you. We were going to have submitter, I think it's Chris Bruce, was going to join. We've heard that they've got some technology issues and are unable to join. We will make sure that we get to the appropriate part of the hearing where we mention what their concerns were and the evidence that and the submission that they made. So with that, I would move that the report of the planning consultant be taken as read. Martin or Stephen, one of you going to put your hand up to second that?
Second that.
Second is Stephen. All in favour?
Aye.
Thank you. Now I've got something on my screen that's annoying me. Get rid of it. Go away. It's gone. It's good. And so with that, I'll ask the applicant or Mr. Dimmock or Mr. Reid to present any further submissions you may wish to make.
Okay, I'll lead off. First of all, we adopt the planner's report as evidence, and we agree with all of its conclusions. What this is about, it's the removal of the consent notice condition on a 2-hectare lot, which is part of a 50-lot subdivision up the top of Springvale there, Nelson Ridge Road. What the condition says is that the lot can only be used for utility purposes. So if you take away this consent notice condition, it theoretically enables someone to build a dwelling on the site. I have to note though that any application to build a dwelling would be subject to a further resource consent application. So it's not just an open-ended sort of a thing, by automatic. The other point to bear in mind is that this is not a subdivision, as it's already subdivided into a separate title, therefore doesn't create any precedent for subdivision. But in any case, if we had going back to the original 50-lot subdivision, considering it as a whole, this particular title would have complied with the minimum 2-hectare and the average 8-hectare rule in any case, just that it was decided that it was going to be used for utility purposes. As we've explained several times, including in the request for further information, there's no prospect whatsoever that this lot will ever be used for utility purposes. The utility purposes are on another lot at the south end of the subdivision. Everything's there, including the pump station and the water treatment plant. The water comes from miles away at Waikirikiri Valley Road, pumped about 9 kilometres to this other lot, which is quite small, less than about half a hectare. Everything's there, and then it's further on pumped from there to the 50 lots. So So there's no prospect whatever that this site will ever be used for utility purposes. So it's just really a waste of land, just leaving it as an unoccupied bare land, long grass, untended site. I mean, what else can you do with the lot? The other point to make is that this is part of a 50 lot rural residential subdivision. So the housing is not unexpected in this area. The other thing to think about, as Mr. Whitney's pointed out, if it were to be used for utility purposes, I mean, from a visual viewpoint, what would you rather have, a nice attractive dwelling there, or an ugly reservoir, or a horrible standard tin shed building? I mean, you've got to look at the visual effects. That this land is probably much better off than being in a long untended grass, just empty space, or in an ugly building. With regard to submitted Staples concerns about if a dwelling was built there, if it was built there, we have to emphasise, there will be no room for utility infrastructure. Well, there's a pretty simple answer to that. There is not, and there will never be utility infrastructure on the site. There's perhaps only one other point I'd like to make, is that both of the submitters are not members of the water scheme which owns the site, so their interest in it being held for utility purposes is somewhat not particularly applicable to them personally. That pretty much concludes what I have to say. Graham, have you got anything further to add at all?
No, I think you've summed it up, Mr. Whitney's report. I'm in support of that, certainly, and I think you've summed it up very, very well. And particularly the irony, I guess, is that the two objectors, if they ever felt the need for water, one is the company doesn't have the ability, or indeed the availability of water anyway, beyond what it already has, and that doesn't provide for irrigation. But they are certainly not members of the scheme, and yeah, I find there's somewhat of an irony there. But no, I've got nothing more to say. Thank you.
Thank you, Mr. Dimmock and Mr. Reid. And questions? Mr. Dimmock, you did make the observation that obviously for any building to take place there will require resource consent application by a future applicant / owner. And I suppose it doesn't dismiss the possibility that one day the owners of the two adjoining lot might say actually they want to have a share of that lot each and buy it off whoever the future owner is going to be as well.
Who knows?
Yeah, who knows? Yeah, cool. That's right. Yep. No, I've got no particular questions. Panel, Stephen.
You just covered it perfectly.
Martin.
No, nothing from me.
Nothing from you. Right. Thank you. Mr. Whitney, any questions from you, sir?
Yeah, I've just got 2 or 3 points that might just help get a bit of clarification. I guess the first, and I think I'll do these in turn so that Peter can respond to each of them rather than giving you a bundle of questions, Peter. So the first one, just going back to the Staples submission, which said, or raised the issue about if you take this lot out for some other purpose, that it wouldn't be available for infrastructure and utilities. And you've specifically answered that at that point. But as I said in the planning report, it's quite interesting, the original history of this lot, that it was originally intended to be sort of like a common land or a reserve of the small R for the benefit of the local residents. Is that in any way a practical situation now, given that the subdivision has proceeded?
No, not really. It's got quite a complex history. It's been through 2 resource consents.
Yeah.
Basically, it's for utility purposes. There's no proposal anymore that's gone by the board that it'll ever be used as some sort of a common lot. It's not owned by anyone in common. Who would own it? It's owned by the water company. That was so. Yeah, no, there is no issue there.
Mr. Chairman, I wonder if I could just add to that. And it was a troubled subdivision, and it was originally intended, I believe, that the all 50 properties would be members of the water scheme. Due to, it's no use going into the circumstances at the time. but we have, I think, 33, 34 members. So the benefit, the others that have not joined, they could hardly claim to have an interest in a reserve or a common facility that is maintained by an entity they choose not to contribute to.
Okay, thank you. The next question as well for Mr. Dimmock. It's a matter that was raised in the Bruce submission, Peter, which is the question of fencing. Mr. Bruce has said no one has approached him to discuss compensation for his fence or the upkeep maintenance of the grass/foliage fire risk. I was wondering whether you had any particular response to that.
Well, my response is that it's a private matter between the parties, not a resource consent issue, and I think Graham's probably got some more comments about that as well.
Yes, I have. Obviously, the water company has maintained the outgoings in terms of rates and so forth. Mr. Bruce, yes, he has erected a farm fence. There is provision for him, of course, under the Fencing Act to have approached me, but somewhat of an irony really is that he's been using the block as a supplementary grazing unit for stock that he has on the adjacent property, and I've stood back from that, and he's doing me a favour and I'm doing him a favour.
Okay, thank you for that. And the third question I had, Peter, just relates to if you like, the topography of the site and its suitability. And I realise this is not a land use consent for a dwelling, but as noted in the report, there are sort of water courses and such like dividing up the site. Are there any significant constraints to ultimate residential use or not?
No, we did have a section 42A report which raised the issue that if you take out the separation from the water courses, there wouldn't be any land left to build on. I did provide a plan showing that there would be ample land, and probably includes the best site for a dwelling anyway. So
is that the piece sort of to the rear centre of the site?
Yeah, right in the middle there. There's a sort of a V there, and there's ample with dwelling heaps of land.
And presumably, and presumably you'd need some culverting or some such to be able to pass over the water courses for the
there would have to be a culvert, yeah. Yes, there would have to be a culvert. That's quite correct.
Okay, thanks. I've got no further questions.
I have to also advise that the water courses are dry for most of the year. They don't often run, except the exceptional rainfall events.
Yeah, thank you.
Well, just on that, they seem to form part of the wider catchment that drains down through the property across the road and so on and so forth.
That is correct, but as I said, all those gullies at Springvale, apart from one or two of the larger ones that come off the Dunson Range, are dry for 99.9% of the time.
Yeah, no further questions, Mr. Chairman.
Thank you, Mr. Whitney. We'll see what global warming does to that going forward. Mr. Campbell, I think you might have a question you want to ask.
Yes, thank you, Mr. Chair. Just a hypothetical question, perhaps for Mr. Reid. In terms of the neighbouring properties, could they become members of the water company in future?
We would certainly welcome the non-members to join, yes, but when I, if you like, became involved probably 10 years ago now, there was, but I proceeded because we had commitment from Dominion Finance, which was in receivership at the moment, and we would have had all properties involved in the scheme, and there was certainly I'll say a tremendous amount, relatively a great amount of debt involved. There were missing easements, etc., etc. Now, the members that joined at that stage, because Dominion changed its mind, the receiver changed its mind and backed out, the ones that did proceed and enabled the problems to be resolved outlaid a considerable amount of money, and that, in addition to borrowings, is why we are where we are today. Those members made it clear that they were not prepared to fund people that joined in 10 years' time. So the intention is that there would be a joining fee for those outstanding, quite a reasonable one, and I'm told a very reasonable, I think it's 4,000 or 5,000 each. So they would have to get over that hurdle and, of course, contribute to the operational costs, which would bring the overall operational costs down. It's, you know, the water company is a non-profit making entity, and this will enable it to be, its future to be reviewed and perhaps handed over to those that rely on it.
So I guess the short answer is yes. So welcome to join.
Yeah, no, that's clarified that. Thanks.
Cheers, David. Okay, thank you. Now I would normally go to our submitters to make any submission they'd like to make, but as we've noted, Mr. Bruce is unable to join due to technology issues. So just note that the submission that was there was in relation to in the middle. I had the page a moment ago, and of course now it's not there.
Summaries at 373, Mr. Chairman.
Thank you. I knew it was just one page I hadn't turned over to. So they opposed it because lots 18 and 19, which adjoin it, were classified, bought it knowing that 53 was classified as utilities block. Yes, thank you. And they say there that no house could be built on this land, and I'm not quite sure that would necessarily be entirely true. It didn't say that it couldn't be a house built, just the expectation maybe that there wasn't one. Would that be a fair observation to make?
No, Mr. Chairman, because the effect of the consent notice condition is to prevent that.
Cool, thank you. Yes, and then he's saying that it would allow similar lots to be similar lot sizes to be done, and that's always a risk regardless of this application or not. And as Mr. Dimick has already pointed out, if this had been proposed in the original subdivision application, if I understand it correctly, to be a lot of that size, not for utility purposes, it would have met all the rules and been permitted. Is that correct, Mr. Whitney too?
Yes.
Yeah, cool. And yeah, and the fencing matter's been covered. You know, yes, I'm sure you could talk to Mr. Reid about a fence, and then they could talk about also a grading lease, and I'm sure they'd have an interesting conversation.
Good, Mr. Chairman, could I add just one point? It might be relevant. I understand Mr. Bruce has his own water supply.
Okay.
He's certainly carrying stock there, and he takes it out of a dam higher up. He's got a couple of water tanks, so he certainly has access to water other than our scheme. Yeah,
okay. Well, as I say, he's welcome to join your scheme, and we'll let that go. So just in terms of the process, just make sure that the submitters' concerns, I have summarised them for benefit of the panel and those attending the hearing. So at least the meeting will record that we were aware of what the issues were, and Mr. Stuffle's ones have been worked through as well. Obviously, we can't ask Mr. Bruce any questions. On that basis, I guess it's back to the applicant to have any right of reply, and we can then go to the next step. So, Mr. Dimick.
Nothing further to add.
Sounds good to me. So on that basis, I have to say that the decision of the hearings panel is reserved. The formal decision will be in writing and will be available within the statutory period of 15 working days. In the event that the release of the decision is delayed, the applicant will be advised of the delay. The hearing is now adjourned. Thank you, Mr. Reid. Thank you, Mr. Dimick.
Thank you.
We're all done. Cheers.
Thank you.
So Mr. Dimick and Mr. Reid are leaving. That's good. That means that we can probably do our deliberations now, can't we? Would make sense, wouldn't it?
Yep.
Sounds good.
Yep.
And yep. I assume we're still recording. I see, Sue. So we should well
Stop.
Should stop. Yes.
Stop.
Yeah.
If I can.
That could be a fatal flaw, isn't it?